Before we dive in, a quick but important note. This presentation is for educational and informational purposes only and does not constitute legal advice. I am not an attorney. The laws governing games of skill and chance are incredibly complex, constantly evolving, and vary dramatically from state to state, and even city to city. For advice on a specific situation, you should always consult with a qualified legal professional licensed in your jurisdiction. Imagine it's 1954. You walk into a smoky bar in Rochester, New York. In the corner, there's a brand new machine, gleaming under the dim lights. It's a pinball machine. But this isn't just for fun. High scores win you free games. The city of Rochester calls it gambling, a device of chance corrupting the youth, an illegal lottery in a box of lights and springs. They want it banned. The case goes to court. In a moment of legal theater, the pinball manufacturers will a machine right into the courtroom. They call up their star witness, a pinball wizard named Sharp. In front of the judge, Sharp calls his shot. He announces like a pool hustler exactly which bumpers the steel ball will hit and what his score will be. And then he does it. He plays with such precision, such mastery, that the judge is forced to conclude that pinball is not a game of chance. It is a game of skill. And with the bang of a gavel, pinball is declared legal. That one courtroom performance over half a century ago highlights a billion-dollar question that American law has been wrestling with for over a century. Where exactly is the line between a harmless game and illegal gambling? That line is the difference between DraftKings being a publicly traded company and its founders being in jail. It's why you can legally bet on a horse race in most states, but playing online poker for money might land you in serious hot water. And it's why your friendly office March Madness bracket pool is, in the eyes of the law in many places, probably illegal. Understanding this distinction isn't just for lawyers or casino owners. It affects the video games you play, the fantasy sports leagues you join, and the very definition of what constitutes a fair game in America. In this video, we are going to crack open the legal code. We're going to explore the bizarre, contradictory, and fascinating journey of how U.S. laws separate skill from chance. You'll discover the critical legal tests courts use to make these decisions, why a game can be perfectly legal in Nevada but a felony in Utah, and how tech entrepreneurs and game designers walk this legal tightrope every single day to bring you the games you love. The first thing you have to understand is that there is no single nationwide definition of gambling in the United States. It's a mess. Congress has passed a few major laws, like the Unlawful Internet Gambling Enforcement Act of 2006, or UIE. That's the law that made it a nightmare for online poker sites to operate in the U.S. by targeting financial transactions. But even that massive federal law had a specific carve-out, a little exception written in for, of all things, fantasy sports. That one sentence, that one exception, is arguably responsible for the creation of a multi-billion-dollar industry. But for the most part, defining and regulating gambling is left up to the individual states. And the states, well, they do not agree. At all. 50 states, 50 different sets of rules. It's a legal minefield where crossing a state line can turn a legitimate business into a criminal enterprise. So how does a court, a prosecutor, or a state legislature decide? How do they draw that line in the sand between skill and chance? They use legal tests developed over decades of strange and specific court cases, just like that pinball wizard in New York. While there are a few variations, most states rely on one of two major tests. The first, and most common, is called the dominant factor test. It's also known as the predominance test, and it's the standard in the vast majority of states, including giants like California, New York, and Texas. The dominant factor test is exactly what it sounds like. It asks, what is the dominant factor in determining the winner? Is it skill or is it chance? The law acknowledges that almost no game is 100% skill or 100% chance. Life itself is a mix of both. Chess, a game almost universally considered to be pure skill, still has a tiny element of chance in the coin toss that decides who plays white and gets the first move. A single roll of the dice in a game of craps is almost pure chance, but a skilled player can make strategic bets over time to manage their odds. The dominant factor test doesn't care about tiny, incidental elements of luck. It looks at the game as a whole and asks, what matters more? To win consistently, do you need to be lucky, or do you need to be good? Think of it like a recipe. A game is a mix of two ingredients, skill and chance. If the final dish is more than 51% skill, then the law in most states will call it a skill game. If it's more than 51% chance, it's a game of chance, and if you're wagering money on it, it's probably illegal gambling. Let's apply this to the ultimate case study, poker. Specifically, Texas Hold'em. Is it skill or chance? The element of chance is obvious and undeniable. You have no control over the cards you're dealt. You can get a terrible hand, the flop can go against you, and an opponent can hit a miracle one-outer on the river to beat you. That is pure, unadulterated luck. But what about the skill? A skilled player understands mathematics and probability. They can calculate pot odds, implied odds, and reverse implied odds in a split second. They are masters of psychology, able to read the subtle tells of their opponents. A twitch, a glance, a change in breathing. They employ sophisticated betting strategies, knowing when to be aggressive, when to fold, and how to use their chip stack to apply pressure. They understand position, game theory, and how to adapt their playstyle against different opponents. So what's the dominant factor? In the long run, do the best players consistently win? The evidence overwhelmingly says yes. The same handful of professional players make it to the final tables of the World Series of Poker year after year. It's not because they are the luckiest people on earth. It's because their skill at navigating the elements of chance is the dominant factor in their success. And that is why many states operating under the dominant factor test have ruled that poker is a game of skill, and therefore not illegal gambling per se. But not all of them do. And that but is a massive, complicated legal problem. Because some states look at that same game of poker with the same cards and the same rules and come to the exact opposite conclusion. They use a different, far more restrictive legal test. It's called the any chance test. And it is as unforgiving as it sounds. Under this test, if a game has any meaningful element of chance whatsoever, it's classified as gambling. It doesn't matter if the game is 99% skill and 1% chance. That 1% is enough to make it illegal if money is on the line. This is the test that keeps game developers up at night. It's the reason why the legal map of gaming in America is so fractured. And it's the test we're going to break down next because it explains how a state could, in theory, ban everything from a friendly game of Scrabble for $5 to that claw machine at the movie theater. This all comes down to one of three legal frameworks that states use to draw the line in the sand, and the one most states use is called the dominant factor test. It's also known as the predominance test, and the name gives away the secret. The core question is simple. What is the dominant factor in determining the winner? Is it the player's skill or is it pure dumb luck? The law isn't asking if chance is involved. It knows chance is almost always involved. The dice have to be rolled, the cards have to be dealt. The question is, does skill predominate over that chance? Think about poker. It is the quintessential case study for the dominant factor test. The element of chance is obvious and unavoidable. You have absolutely no control over the cards that are dealt to you. You could be the best player in the world and get dealt a 7-2 offsuit 10 hands in a row. That's luck, and it's a powerful force in the game. But is it the dominant force? Proponents of poker as a skill game argue, absolutely not. They point out that over the long run, a skilled player will consistently beat an unskilled one. Why? Because of all the other factors they control. A skilled player understands probability, they can calculate pot odds in their head, they can read other players for tells, they know when to bluff, when to fold, and how to manage their chip stack. They are playing the other players as much as they are playing the cards. In this view, the cards you're dealt are just the chaotic raw material, and skill is the factory that turns that material into a winning or losing outcome. A court in a dominant factor state has to weigh these two things. They might hear expert testimony. They might look at studies showing the long-term success rates of professional players versus amateurs. They're trying to figure out if the game is more like chess or more like a lottery ticket. If they conclude that skill is the heavier weight on the scale, that a player's decisions are more impactful than the random fall of the cards, then poker is a game of skill. And if it's a game of skill, it's generally not considered illegal gambling. This same logic is the bedrock upon which the entire multi-billion-dollar daily fantasy sports industry was built. Companies like DraftKings and FanDuel have spent millions in legal fees arguing that their contests are skill-based. Their argument is that winning isn't about luck. It's about deep research, statistical analysis, understanding matchups, predicting player performance, and managing a salary cap. The chance element, a star quarterback tearing his ACL on the first play of the game, is present, but they argue it's not the dominant factor. In states that use this test, they've often been successful. But what if the law is even stricter? What if it doesn't care about what dominates? This brings us to the second and far more severe legal standard, the any chance test. This test is exactly what it sounds like. If there is any element of chance that plays a role in the outcome, the game is legally a game of chance. Period. It doesn't matter if skill makes up 99.9% of the game. If that last 0.1% is pure luck, the entire game gets classified as gambling. This is the legal sledgehammer. It's an incredibly restrictive and rare standard, but in the states that use it, the consequences are enormous. Let's go back to that friendly game of Scrabble for $5. Under the dominant factor test, Scrabble is a game of skill, hands down. Your vocabulary, your ability to see placements, your strategy in using bonus squares, that's what determines the winner. But under the any chance test? It's a different story. The skill is still there, but what about the letters you draw from the bag? That is an act of pure, unadulterated chance. You could be a walking dictionary, but if you keep drawing a rack full of vowels, you're going to lose to a lesser player who happens to draw the Z and the Q with a blank tile. Because that element of chance exists and can affect the outcome, a state using the any chance test could classify Scrabble as a game of chance, and therefore illegal gambling if stakes are involved. The same goes for that claw machine. You might argue there's skill in timing the drop and positioning the claw, but there are so many elements of chance. The grip strength of the claw is often programmed to be weak, to only pay out after a certain number of attempts. The way the prizes are piled is random. The slight sway of the claw is unpredictable. Under the any chance test, it's not even a close call. The existence of those random variables makes it a game of chance. This test is so strict that it could, in theory, outlaw a game of billiards if the players used a coin flip to see who breaks first, because that initial coin flip is an element of chance that has some small effect on the outcome. It's a blunt instrument, and it's why most states have moved away from it. Simply too broad. So we have the most common test where skill has to be the dominant factor, and the strictest test where any chance at all can poison the well. But there's a third way, a kind of murky middle ground known as the material element test. This test asks a slightly different question. It doesn't ask if chance is dominant, and it doesn't ask if chance is merely present. It asks if chance is a material element of the game. So what does material mean? That's the million-dollar question, and it's where the lawyers make their money. Generally, it means that the element of chance has to be significant. It has to be an important, essential part of the game's character, not just some trivial background noise. It's a more flexible standard than the any chance test, but it's more restrictive than the dominant factor test. A great example here is backgammon. Backgammon involves incredible skill. Top-level players have memorized thousands of opening moves, they understand probability on a profound level, and their long-term strategy is incredibly complex. But every single move is constrained by the roll of 2 dice. You cannot move without first rolling the dice. The dice roll isn't a small part of the game. It is the fundamental mechanic that dictates your options on every single turn. Under the dominant factor test, you could argue that skill in managing those dice rolls is the key to winning over time. But under the material element test, it's much harder to argue that the dice roll isn't a material element. It's central to the entire contest. Therefore, a state using this test might very well classify backgammon as a game of chance, even while acknowledging the high level of skill involved. These 3 tests, dominant factor, any chance, and material element, are the hidden legal software running in the background of American gaming law. They are the reason a game like poker can be celebrated as a sport in one state and prosecuted as a crime in another. It all depends on which of these fundamental philosophies a state has chosen to adopt. It's a patchwork of legal interpretations that has been built up over more than 2 centuries of court cases, legislative debates, and moral arguments. And some of those court cases are absolutely fascinating. They involve everything from church bingo nights to dusty old pinball machines, and they reveal how judges have been forced to become game theorists, deciding the very nature of play itself. In fact, the battle over one of America's most beloved arcade games went all the way to a city's highest courts and forced a legendary game designer to prove, in person, that his creation was more than just a game of luck. The year is 1982. A cultural phenomenon is sweeping the nation, accompanied by a synthesized, hypnotic soundtrack of Waka Waka Waka. Pac-Man Fever isn't just a novelty song. It's a reality. Arcades are the new town squares, glowing hubs of social life for an entire generation. And at the center of it all is a little yellow circle with an insatiable appetite. But not everyone is thrilled. To many city officials and concerned parents, these dimly lit arcades are dens of delinquency, noisy machines designed to gobble up quarters and corrupt the youth. In Nashville, Tennessee, this moral panic found a legal weapon, a city ordinance that banned coin-operated games of chance. And in the eyes of Nashville's legal department, Pac-Man, the world's most popular video game, was nothing more than a high-tech slot machine. The city's argument was simple, and on the surface it made some sense. To the average first-time player, the game felt chaotic. For brightly colored ghosts, Blinky, Pinky, Inky, and Clyde chased you through a maze. Their movements seemed erratic, unpredictable. Success felt like a matter of luck. Did you happen to zig when the ghost zagged? Did you stumble upon a power pellet just in the nick of time? For the city, this randomness was the hallmark of a game of chance. So they started taking action. Police began raiding arcades, unplugging and seizing Pac-Man machines as illegal gambling devices. Arcade owners faced fines, the loss of their most profitable machines, and potentially the end of their businesses. But this was bigger than Nashville. This was an existential threat to the entire video game industry. If Pac-Man could be outlawed, any game could. The case, officially known as Coin-Operated Entertainment Incorporated versus the City of Nashville, became the front line in the war to define what a video game even was. The arcade owners fought back. Their defense rested on a single powerful claim. Pac-Man is a game of pure skill. To prove it, they brought in expert witnesses, not lawyers or academics, but teenagers, local arcade wizards who had mastered the game. In the courtroom, they put on a dazzling display. They didn't just play, they performed. They executed perfect turns, cleared entire screens without stopping, and explained the intricate strategies they used to group the ghosts together before devouring them with a single power pellet. They spoke of patterns, predetermined routes through the maze that could guarantee a perfect score on certain levels. This, they argued, was the opposite of chance. It was memory, reflexes, and strategy. It was skill. But the city's attorneys were unconvinced. They cross-examined the young experts, painting them as a tiny, obsessive minority. Sure, they could find patterns. But what about the millions of other players? For the 99% of people putting a quarter in the slot, wasn't the outcome still predominantly based on luck? They argued that the ghost's behavior was too complex, too random for an ordinary person to decipher. The judge seemed to be siding with the city. The live demonstrations were impressive, but they didn't fundamentally prove that the game's core mechanics weren't random. The case was slipping away. The arcade owners and their legal team knew they needed something more. They needed to go to the source. They needed the man who created the ghosts in the first place. In an extraordinary move, they flew a man from Tokyo, Japan, to a courtroom in Nashville, Tennessee. His name was Toru Iwatani, the creator of Pac-Man. He was a quiet, thoughtful designer, not a showman. But in that courtroom, he delivered one of the most important testimonies in video game history. Through a translator, Iwatani didn't just play the game. He deconstructed it. He explained his design philosophy. He revealed that the ghosts were not random at all. In fact, each one was programmed with a distinct and unwavering personality, a specific AI algorithm designed to create a complex, but ultimately predictable, challenge. He broke it down for the judge, ghost by ghost. Blinky, the red one, he explained, is the pursuer. His programming is simple. Find the shortest route to Pac-Man and follow it. He's the aggressor. Pinky, the pink ghost, is the ambusher. Her code tells her to target the space 4 tiles in front of Pac-Man's mouth, trying to cut him off and trap him. She's strategic. Inky, the blue ghost, is the most complex. His movement is based on a calculation involving both Pac-Man's position and Blinky's position, making him a wild card who can either flank you or get confused. He's fickle. And then there's Clyde, the orange ghost. Iwatani explained that Clyde is programmed to be stupid. He chases Pac-Man like Blinky, but when he gets too close within 8 tiles, his programming flips, and he retreats to the bottom left corner of the maze. He's a coward. The courtroom was mesmerized. This wasn't a description of a game of chance. This was the blueprint for a sophisticated machine of logic and rules. Iwatani revealed that the ghosts' scatter modes, where they retreat to their corners, weren't random breaks. They happened at precise, timed intervals. The patterns the expert players had discovered weren't glitches. They were the inevitable result of a player's perfect inputs interacting with the ghost's predictable code. He was, in essence, lifting the hood on the game and showing the judge the intricate, skill-based engine chugging away underneath. He proved beyond any doubt that every single element of the game that seemed like luck was, in fact, a product of deliberate, predictable design. Success wasn't about a lucky break. It was about understanding and mastering a complex system. The testimony was a knockout blow. The judge, now fully understanding the deep layer of strategy beneath the game's surface, reversed his position. He ruled decisively in favor of the arcade owners, declaring Pac-Man a game of skill. The decision was a landmark victory. It set a crucial precedent that helped shield the entire video game industry from being misclassified and regulated out of existence by anti-gambling laws. It affirmed that digital entertainment could be just as much a test of skill as chess or pinball. The Nashville case drew a bright, clear line in the sand, demonstrating that when a player's decisions and performance are the dominant factors in determining the outcome, the law recognizes it as a game of skill. But this legal clarity was born from a game with clear, programmable rules. What happens when the core of a game is intentionally designed to be a perfect, inseparable fusion of both skill and chance? The next great legal stress test wouldn't be fought over joysticks and pixelated ghosts, but over felt tables, a deck of 52 cards, and the unpredictable turn of a river card in the booming world of professional poker. The year is 2003. An accountant from Tennessee, a man with the almost impossibly perfect name of Chris Moneymaker, enters a $39 online satellite tournament. He wins. That win gets him a seat at the $10,000 main event of the World Series of Poker in Las Vegas. He is an amateur in a sea of sharks, the living embodiment of a long shot. And then, against all odds, he wins the whole thing, taking home $2.5 million and the most coveted prize in the sport. The moneymaker effect was instantaneous and seismic. Suddenly, poker wasn't a smoky backroom game for grizzled old-timers. It was a televised sport on ESPN, a path to fame and fortune accessible to anyone with an internet connection and a little bit of luck. The online poker industry exploded. Millions of Americans were logging on, playing for pennies or for thousands of dollars, all chasing that same dream. The game was framed as the ultimate American meritocracy, a contest of nerve, intellect, and strategy where the best player would, over time, come out on top. But with this explosion of money and popularity came a massive, unavoidable question, one that would put the industry on a collision course with the United States government. Was this a sport? Or was it just gambling dressed up in a tuxedo? The federal government saw billions of dollars flowing through unregulated, offshore websites with zero oversight and zero tax revenue. And in 2006, they decided to act. The hammer came down in the form of the Unlawful Internet Gambling Enforcement Act, or UIG. This was a piece of legislation cleverly attached at the last minute to a must-pass port security bill. It didn't explicitly make playing poker online illegal for individuals. Instead, it did something far more effective. It made it illegal for banks and financial institutions to process payments to and from online gambling sites. It aimed to starve the industry by cutting off its access to the American financial system. The law, however, contained a fascinating and crucial carve-out. It specifically exempted games of skill, including fantasy sports, chess, and other contests where outcomes were determined by the relative knowledge and skill of the participants. And so the entire multi-billion-dollar poker industry found itself hinging on that one, age-old legal question. Is poker a game of skill or a game of chance? The argument for chance is simple and intuitive. The cards you are dealt are completely random. The 5 community cards that come on the flop, turn, and river are random. In any single hand, a complete novice with a lucky draw can beat the world's best professional. If the predominant factor test is applied, the test used in many states that asks what single element most determines the outcome, it's easy to argue that the random distribution of cards is that factor. The government's position was clear. Poker involves wagering on a future contingent event not under your control, the very definition of gambling. But the argument for skill is far more nuanced and, to its proponents, far more compelling. Poker professionals argued that while luck dominates in the short term, skill is the undeniable factor in the long run. A professional player isn't gambling on a single hand. They are making a series of calculated investments over thousands of hands. They use advanced mathematics to understand pot odds and equity. They employ complex game theory. They are masters of psychology, capable of reading an opponent's subtle tells or projecting a false image of strength or weakness. The skill in poker isn't about controlling the cards you're dealt. It's about maximizing your wins and minimizing your losses based on incomplete information. It's a game of risk management, not a lottery. Proponents argued that if you apply the material element test, which simply asks if skill is a significant or important factor in the outcome, then poker passes with flying colors. The same professionals win year after year for a reason, and it isn't because they are the luckiest people on earth. This abstract legal debate soon found a very real-world battleground in a federal courtroom in Brooklyn. The case was United States versus DiCristina. Lawrence DiCristina was running a small, live poker game out of a warehouse. He was charged under a federal statute called the Illegal Gambling Business Act. His defense was simple and audacious. The law he was charged under only applied to illegal gambling, and since poker is a game of skill, it wasn't gambling. Therefore, he had committed no crime. The judge in the case, Jack Weinstein, decided to take this argument seriously. He turned his courtroom into a seminar on the nature of poker. He allowed expert testimony from a statistics professor, who presented data showing that the results of skilled players were not random. Over a large sample of hands, their performance deviated so far from chance that it could only be attributed to skill. Poker professionals were brought in to explain the intricate strategies involved. In a landmark 120-page ruling in 2012, Judge Weinstein agreed with the defense. He wrote, "The most skillful players are consistent winners." He concluded that skill, not chance, was the predominant factor in poker. He meticulously dismantled the government's argument, stating that the influence of skill was overwhelming. For the poker world, it was a moment of incredible vindication. A federal judge had looked at the evidence and declared poker a game of skill, seemingly providing a legal shield for the entire industry. But the victory was short-lived. The government appealed, and the Second Circuit Court of Appeals overturned Judge Weinstein's decision. Crucially, they didn't overturn it because they thought he was wrong about poker being a game of skill. In fact, they didn't address that question at all. Instead, their ruling was based on a dry, technical interpretation of the law. They argued that the plain text of the Illegal Gambling Business Act was broad enough to include poker, regardless of whether it was skill-based or not. They essentially said, it doesn't matter if it's a game of skill. Congress wrote a law that is broad, and poker fits under its definition of gambling. This reversal was a devastating blow. It demonstrated the immense challenge of fighting a legal battle on two fronts, one of principle and one of statutory interpretation. You could win the argument about the nature of the game itself, but still lose the case based on how a law was written decades ago. The DiCristina case, along with the lingering power of UE, culminated in the darkest day in online poker history, April 15, 2011, a day known in the community as Black Friday. On that day, the Department of Justice unsealed indictments against the founders of the three largest online poker sites operating in the U.S. and seized their domain names. The websites were shut down, and hundreds of millions of dollars belonging to American players were frozen. The federal government's message was unambiguous. As far as they were concerned under existing federal law, poker was an illegal gambling business. The debate was over. The boom had officially busted. For years, the game was driven back underground, a shadow of its former self. The federal government, by leveraging its power over the banking system and its interpretation of gambling statutes, had effectively made its definition of poker the law of the land, regardless of the game's inherent skill. But this federal crackdown created a power vacuum. And as we would soon see, individual states, with their own laws and their own desperate need for tax revenue, were about to step into that void, ready to start the fight all over again. The next battle wouldn't be in a federal court, but in state legislatures across the country, and it would be fought not over poker, but over the burgeoning billion-dollar world of fantasy sports. The Unlawful Internet Gambling Enforcement Act of 2006, or UIJ, was a legislative bombshell. Tucked into an unrelated port security bill in a last-minute maneuver, it effectively severed the arteries of online poker in the United States. It made it illegal for banks and financial institutions to process payments for online gambling sites. Poker players woke up one morning to find their accounts frozen and their favorite sites blocked. The online poker boom was over. But buried deep within the text of this restrictive law was a peculiar and incredibly specific exception. Carve-out. The law explicitly stated that its prohibitions did not apply to fantasy or simulation sports games, so long as the value of the prizes wasn't determined by the number of participants or the fees they paid, and the outcome was determined by the relative knowledge and skill of the participants. This carve-out was the legal equivalent of a secret passage. While the front door was being barricaded against poker, a side door was intentionally left wide open for a different kind of game. Why? The fantasy sports industry, led by the Fantasy Sports Trade Association, had lobbied Congress hard. They painted a picture of their game that was completely distinct from the smoky backrooms and digital card tables associated with gambling. Their argument was simple and powerful. Fantasy sports are not about luck. They are about skill. You aren't betting on a team to win or lose. You are the general manager. You are the scout. You are the analyst. Think about it. In season-long fantasy football, you spend weeks before the season even starts researching. You analyze player statistics from previous years, you study coaching changes, you pore over strength of schedule charts. You participate in a draft, a complex strategic exercise of predicting player value and anticipating your opponent's moves. And once the season starts, the work continues. You have to decide who to start and who to sit each week based on matchups. Is your star running back going up against the league's best run defense? Maybe you should bench him. Is your backup quarterback facing a team with a terrible secondary? Maybe he's the smart play. You have to monitor injury reports, navigate by weeks, and scour the waiver wire for hidden gems. This, they argued, was not the random flip of a card or spin of a wheel. This was a cerebral contest, a months-long marathon of strategic decision-making. The element of chance, a star player tearing an ACL on the first play of the game, was present, just as a CEO can have a sudden heart attack and tank a stock. But it wasn't the dominant factor. Over the long haul, the most knowledgeable and skillful manager would almost always come out on top. Congress bought it. The carve-out was secured. And for a few years, fantasy sports continued to grow steadily, mostly in the traditional, season-long format played among friends and coworkers. But in the fertile ground of that legal exception, a new, faster, and far more potent version of the game was about to sprout. Two companies, FanDuel and DraftKings, saw the potential. They looked at the season-long model and asked a critical question. Why wait an entire season to determine a winner? Why not a week? Or better yet, a single day? And so, Daily Fantasy Sports, or DFS, was born. The concept was intoxicatingly simple. Instead of drafting a team for a whole season, you draft a new team every single day, or every weekend for the NFL. You get a salary cap, say $50,000, and you have to fill your roster with players who each have a different price tag. A superstar quarterback like Tom Brady might cost you $10,000, while a rookie wide receiver might cost only $3,000. The goal is to build the optimal lineup within the cap that will score the most fantasy points that day. You could enter a contest for $1 or $5 or $1,000, competing against tens of thousands of other people for massive cash prizes. Suddenly, the slow, strategic burn of season-long fantasy was replaced by the explosive, instant gratification of a daily contest. And the industry exploded. FanDuel and DraftKings blanketed the airwaves with commercials, promising life-changing sums of money. During the 2015 NFL season, you couldn't watch a game without seeing their ads, one after another, featuring ordinary people holding giant checks, celebrating wins of $1 million. The message was clear. You with your sports knowledge could do this too. The market responded. These companies went from small startups to billion-dollar behemoths almost overnight. But this new high-speed version of fantasy sports started to look and feel a lot less like a friendly office pool, and a lot more like a trading floor, or even a casino. The sheer volume of money and the speed of the action attracted a new kind of player, the shark. These were highly sophisticated, professional DFS players. They weren't just casual fans, they were data scientists. They built complex computer algorithms that could analyze thousands of data points in seconds to generate hundreds of optimized lineups. They would then enter these lineups into mass multi-entry tournaments, effectively crowding out the casual players, the fish. Data began to emerge that was both a powerful defense for the DFS companies and a troubling sign for the industry. One analysis found that just 1.3% of players were taking home approximately 91% of the profits. This became the core of the DFS legal argument. See? It is a game of skill. The same skilled players are winning over and over again. It's not random luck. But for state regulators, this raised an entirely different question. If the average fan has virtually no statistical chance of winning against these high-tech sharks, is it still a game of skill for them? Or is it simply a game where their entry fee is a donation to a professional's bankroll, making the outcome for the average Joe a near certainty of loss? The game's very structure seemed to prove it was skill-based, yet the player experience for the vast majority felt an awful lot like chance. The blitz of advertising and the growing controversy soon caught the eye of state attorneys general, who started to question whether this high-octane daily format was really what Congress had in mind when they wrote the carve-out back in 2006. The first major blow came from New York. In late 2015, Attorney General Eric Schneiderman launched an investigation and came to a stunning conclusion. He declared that daily fantasy sports constituted illegal gambling under New York state law. He sent cease and desist letters to both DraftKings and FanDuel, ordering them to stop accepting bets from New York residents immediately. Schneiderman's argument cut to the heart of the matter. He argued that the dominant factor test in New York, known as the material element test, was different. In New York, a game is considered gambling if the outcome depends in a material degree upon an element of chance, even if skill is also involved. And in DFS, he argued chance was everywhere. A last-second, meaningless touchdown in a blowout game, a punt return for a score, a star player slipping on a wet field and getting injured. These were all chance events that had a material impact on the outcome of a DFS contest. He argued that a player's performance is affected by countless unpredictable events, and that a DFS player is fundamentally wagering on the statistical performance of athletes, which is outside their control. It was, in his eyes, a cleverly disguised sports betting proposition. The DFS companies, now fighting for their survival, fought back. They sued the Attorney General, armed with their data on the sharks. They argued that DFS was no different from a stock-picking contest or even a fishing tournament. Sure, there's luck involved. A stock can get hit with an unexpected news event. A fisherman can happen upon a school of fish. But skill is what ultimately separates the winners from the losers consistently. They were adamant. We are a game of skill, and we are legal under the federal carve-out. The battle lines were drawn. The future of a multi-billion-dollar industry hung in the balance, and courts and legislatures across the country were now forced to confront this new technological beast. They had to look past the marketing, past the algorithms, and ask that same fundamental question that has echoed through American legal history for over a century. Where is the line between skill and chance? The patchwork of state-by-state legal battles that ensued created a chaotic and uncertain landscape. Some states sided with the industry, passing laws to explicitly legalize and regulate daily fantasy sports. Others sided with their attorneys general, banning it outright. This legal fragmentation revealed a deep national divide on the issue, but it also did something else. Cracked the door open. By forcing states to seriously legislate and regulate a game so closely related to sports, it started a conversation that had been dormant for decades. If a state can regulate a game of skill based on athlete performance, what else could it regulate? The fight over DFS, it turned out, was just the warm-up act for the main event, the complete, nationwide legalization of sports betting itself. And to understand that main event, you have to understand the one federal law that stood in the way of everything. A law that, for a quarter of a century, had frozen sports betting in time, locking it away in the deserts of Nevada. It was called PASPA, the Professional and Amateur Sports Protection Act of 1992. On the surface, its goal was simple and to many noble: to protect the integrity of sports by stopping the spread of state-sponsored sports betting. The fear was that if betting became widespread, it would invite corruption, game fixing, and would tarnish the purity of the competition. So Congress passed PASPA, which effectively outlawed sports betting nationwide. It grandfathered in the few states that already had some form of it, most notably Nevada, but it slammed the door shut for everyone else. For decades, PASPA was the undisputed law of the land. The major sports leagues, the NFL, NBA, MLB, and the NCAA, defended it fiercely, arguing it was the shield that protected their games from the corrosive influence of gambling. But while the leagues were publicly denouncing betting, an entire generation of fans was growing up with a very different relationship to sports. They were playing fantasy football, filling out March Madness brackets, and talking about point spreads not as a threat, but as a way to engage more deeply with the games they loved. The world had changed, but the law hadn't. And one state, more than any other, was ready to fight it. Enter New Jersey. The Garden State had a problem. Its once glamorous casino hub, Atlantic City, was fading. Casinos were closing, jobs were disappearing, and the state was desperate for a new source of revenue. They looked at the billions of dollars being wagered illegally on sports every year and saw a solution. They saw a way to revitalize Atlantic City, create jobs, and capture tax revenue that was flowing into the shadows of the black market. In 2011, New Jersey voters overwhelmingly approved a state constitutional amendment to legalize sports betting. The people had spoken, but PASPA stood in their way. So New Jersey, led by its famously combative governor Chris Christie, decided to do the unthinkable. They decided to challenge the federal government. They passed a law to license and regulate sports betting at their casinos and racetracks. And just as expected, the major sports leagues and the NCAA immediately sued the state of New Jersey to block the law, citing PASPA. This was the showdown. New Jersey versus the most powerful sports organizations in the world, with the full weight of a 25-year-old federal law on their side. On paper, it looked like an impossible fight for New Jersey to win. How could a single state defy a clear federal statute? But New Jersey's lawyers had a brilliant counterintuitive strategy. They weren't arguing that sports betting was a fundamental right. They weren't even arguing that PASPA was bad policy. Their entire case was built on a much deeper, more fundamental principle of American law: the 10th Amendment and the concept of states' rights. Their argument was that PASPA was unconstitutional because of how it was written. It didn't create a federal agency to regulate betting. It didn't set up a federal prohibition that the FBI would enforce. Instead, PASPA did something very specific. It commanded the states to keep sports betting illegal. It essentially told New Jersey's state legislature, "You are prohibited from changing your own state laws to authorize sports betting." And that, New Jersey argued, was unconstitutional commandeering. Imagine if the federal government passed a law that said, all states must make it illegal to drive over 65 miles per hour, but then provided no federal funding or federal officers to enforce it. It would be forcing state police and state courts to spend their own time and resources enforcing a federal mandate. The Supreme Court has repeatedly said the federal government can't do this. It can't just issue orders to state governments and force them to act as puppets of a federal program. The federal government can either regulate an area itself directly, or it can leave it to the states. What it can't do is force the states to regulate on its behalf. New Jersey's argument was that PASPA was doing exactly that. It was forcing New Jersey to maintain a prohibition it no longer wanted. It was commandeering the state's legislative power. The case, which became known as Murphy v. National Collegiate Athletic Association, worked its way through the courts for years. New Jersey lost, then lost again on appeal. Seemed like PASPA would stand, but they appealed one last time to the highest court in the land, the Supreme Court of the United States. And in 2018, the Supreme Court did something that sent shockwaves through the sports and legal worlds. They agreed with New Jersey. In a landmark 6-3 decision, the court struck down the Professional and Amateur Sports Protection Act. Justice Samuel Alito, writing for the majority, put it plainly: the legalization of sports gambling is a controversial subject, but the legalization of sports gambling requires an important policy choice, and the choice is not ours to make. Congress can regulate sports gambling directly, but if it elects not to do so, each state is free to act on its own. He confirmed that PASPA's command to the states was a direct violation of the anti-commandeering principle. The federal government had overstepped its bounds. With the stroke of a pen, a 25-year-old federal ban was gone. But here's the crucial part. The Supreme Court didn't legalize sports betting nationwide. Did the opposite. Threw the question back to the states. It said, "We're not deciding if sports betting should be legal. We're deciding who gets to decide." And the answer was each and every state legislature. The floodgates didn't just open. The entire dam was obliterated. What happened next was a frantic, chaotic gold rush. Within weeks of the decision, Delaware and New Jersey were taking their first legal sports bets. Other states like Mississippi, West Virginia, and Pennsylvania scrambled to pass their own laws. It was a domino effect, as states watched their neighbors rake in millions in tax revenue and feared being left behind. The very companies that had honed their skills in the legal gray area of daily fantasy sports, like DraftKings and FanDuel, were perfectly positioned. They had the technology, the brand recognition, and a massive database of users ready to convert from fantasy players to sports bettors. They unleashed a marketing blitz unlike anything the country had ever seen, plastering their logos on every stadium, every broadcast, and every podcast. And what about the sports leagues? The very same organizations that had spent years and millions of dollars in court fighting New Jersey, arguing that sports betting would destroy the integrity of their games? They performed one of the most stunning, whiplash-inducing reversals in modern business history. Literally overnight, their moral crusade against gambling vanished. The NFL, which had once refused to even allow a Las Vegas tourism ad during the Super Bowl, suddenly had an official casino partner and was planning to move a team there. The NBA, MLB, and NHL, which had sued to stop New Jersey, were now signing $100 million partnership deals with the very betting companies they had just been fighting in court. They didn't just accept sports betting. They embraced it with the fervor of a convert. They integrated betting odds and statistics directly into their broadcasts. They sold their official league data to betting operators for a fortune. They argued that these integrity fees or royalty payments were necessary to help them monitor for suspicious betting activity. A problem they had previously argued was so great that betting should be banned entirely. The hypocrisy was breathtaking. It became clear that their opposition was never really about the integrity of the game. It was about control and money. As long as they couldn't control it and get a piece of the action, they were against it. The moment the Supreme Court gave them a path to profit, their principles evaporated. The fall of PASPA didn't just change a law. It fundamentally rewired the financial DNA of American sports, creating a powerful, and some would say troubling, new alliance between the leagues on the field and the sportsbooks that take bets on them. The lines were not just blurred. They were erased, replaced by a river of cash. This new river of cash, however, wasn't just flowing into the coffers of traditional sports leagues. It was irrigating a strange new landscape that had been quietly growing in the shadow of federal law. This was the world of daily fantasy sports, or DFS. And it would become the next great battleground in the war between skill and chance. To the casual observer, companies like DraftKings and FanDuel, which exploded into public consciousness around 2014 and 2015, seemed to appear out of nowhere. Suddenly, every commercial break during a football game was a slickly produced ad promising life-changing sums of money for picking the right lineup of players. It felt like sports betting, it looked like sports betting, and it certainly paid out like sports betting. But its creators and their army of lawyers insisted it was something else entirely. It was, they claimed, a game of pure skill. Their argument was undeniably seductive. Unlike betting on a single team to win, a DFS player acts as a general manager. They're given a virtual salary cap and must meticulously construct a roster of players from different teams. To succeed, you couldn't just be a lucky fan. You had to be a statistician, a strategist, a meteorologist, and a psychologist all rolled into one. You had to analyze player matchups, defensive schemes, injury reports, and even weather patterns. You had to predict which star quarterback was due for a breakout game and which backup running back at a bargain price was about to get a surprise workload. This, they argued, was no different than a stock trader analyzing market trends or a chess grandmaster anticipating their opponent's moves. It was a contest of intellect, not a roll of the dice. And they had a powerful, if somewhat accidental, piece of federal legislation to back them up: the Unlawful Internet Gambling Enforcement Act of 2006, or UIG. This was the law that had effectively shut down the online poker boom in the United States. It made it illegal for banks and financial institutions to process payments for unlawful internet gambling. But buried deep within its text was a specific exemption. The law did not apply to fantasy or simulation sports games, as long as the prizes weren't based on the score or point spread of any single real-world team and were established beforehand. This carve-out was written with season-long fantasy leagues in mind, the kind you play with your friends or coworkers over an entire season. It never contemplated a world where you could play a million different seasons in a single day, with billions of dollars on the line. The DFS companies saw this legislative loophole not as a crack in the door, but as a 6-lane superhighway. They floored the gas pedal, arguing that their daily games fit the technical definition of the exemption perfectly. For a few years, this legal shield held. The companies grew into billion-dollar behemoths, fueled by venture capital and the seemingly bottomless appetite of American sports fans. The money was staggering. The advertising was inescapable. They sponsored entire stadiums and signed deals with the very leagues that had, for a century, treated gambling as a mortal enemy. But the bigger they got, the brighter the spotlight became. And soon, state attorneys general across the country began to ask a very pointed question. Is this really just a harmless fantasy game? Or is it a Trojan horse for illegal sports wagering? The first major domino to wobble was in New York. In late 2015, Attorney General Eric Schneiderman launched a full-scale assault, issuing cease and desist letters to both DraftKings and FanDuel. He didn't mince words, calling their operations plainly illegal and a massive multi-billion-dollar scheme. The legal battle that followed became a national spectacle, a courtroom drama that would test the very definition of gambling in the digital age. New York's law was particularly tricky for the DFS companies. It used what's known as the material element test. A game is considered gambling if the outcome depends in a material degree upon an element of chance, even if skill is also involved. The Attorney General's argument was simple and direct. No amount of research or skill can prevent a star quarterback from tearing his ACL on the first play of the game. No statistical model can predict a freak gust of wind that sends a game-winning field goal wide. These unpredictable, chance events are not just minor factors. They are material to the outcome. Your perfectly crafted, skill-based lineup could be worthless in a matter of seconds because of pure, unadulterated luck. Therefore, under New York law, it was illegal gambling. The DFS companies fired back with a mountain of data. Their lawyers argued that while a small element of chance exists, skill is the predominant factor. They presented evidence showing that a tiny fraction of their players, less than 2%, were winning over 90% of all the prize money. These were the sharks, data-savvy professionals who use complex algorithms and automated tools to submit hundreds, sometimes thousands, of lineups. If DFS were truly a game of chance, they argued the winnings would be distributed much more randomly like a lottery. The fact that the same players won consistently was, in their view, irrefutable proof of skill. In a fascinating twist, this very argument, intended to be their legal salvation, became a public relations nightmare. The revelation that a small cadre of professionals were systematically fleecing amateur players soured public opinion and gave ammunition to critics who said the games were not only gambling, but potentially unfair. The legal fight raged, with injunctions filed, rulings and appeals, and a media frenzy that followed every move. Ultimately, the New York legislature stepped in, passing a bill that officially legalized and regulated daily fantasy sports, essentially creating a new bespoke category for it, neither pure skill nor pure gambling, but something in between that the state could tax and control. New York was not an isolated case. A chaotic patchwork of legal opinions emerged across the country. Nevada, the nation's gambling capital, declared DFS to be gambling and said the companies needed to get a gaming license to operate. Texas and Illinois saw their attorneys general issue opinions that it was illegal, leading to further court battles. Meanwhile, states like Massachusetts and Virginia followed New York's lead, passing specific legislation to regulate the industry. For a few years, the legality of playing a DraftKings contest depended entirely on your geographic location. The DFS explosion had forced a national reckoning. It proved that the old definitions, the tests created in an era of horse tracks and backroom poker games, were struggling to keep up with the speed of technology. The line between skill and chance wasn't just blurry. It was being redrawn, state by state, algorithm by algorithm, leaving a fractured and uncertain legal map in its wake. This new digital frontier created a legal game of whack-a-mole. For every law passed, a new app or online platform would emerge, seemingly designed to exist in the gray area between the lines of the law. And no case study illustrates this high-stakes battle better than the meteoric rise of daily fantasy sports. Companies like DraftKings and FanDuel exploded onto the scene, offering millions of dollars in prizes. Their argument was simple and powerful. This isn't gambling. This is skill. They claimed that crafting a winning lineup required deep knowledge of player statistics, matchups, weather conditions, and injury reports. It was, in their view, no different than managing a stock portfolio, a series of calculated decisions based on data. And for a while, that argument held water, thanks to a curious loophole in a 2006 federal law, the Unlawful Internet Gambling Enforcement Act, or UIG. The law was designed to cripple online poker and casino sites, but it included a specific carve-out for fantasy sports, deeming them games of skill. But here's where it gets complicated. That federal law didn't legalize fantasy sports nationwide. It simply said the UA's restrictions didn't apply to them. It left the ultimate decision of legality up to individual states. And the states were fiercely divided. The advertising blitz from these companies, promising life-changing money to average sports fans, drew the attention of state attorneys general. The billion-dollar question was being asked in courtrooms from New York to Texas. Was picking a fantasy lineup a sophisticated act of statistical analysis, or was it just a high-tech lottery ticket? Opponents argued that while some skill might be involved, the ultimate outcome of a player's performance on a given day is subject to immense chance. A star quarterback could have an off day. A key player could suffer a freak injury in the first quarter. A lucky bounce could turn a mediocre performance into a game-winning one. These elements, they contended, were pure chance, making the entire enterprise a form of illegal gambling. The legal whiplash was staggering. In 2015, the New York Attorney General declared daily fantasy sports to be illegal gambling and issued cease and desist orders. The companies fought back, launching a massive lobbying effort and arguing their case in court. Eventually, New York passed a law explicitly legalizing and regulating it. A similar battle played out in Texas, where the Attorney General issued an opinion that it was illegal, leading to a prolonged legal fight. Some states banned it outright. Others embraced it, taxed it, and regulated it. What emerged was not a clear verdict, but that fractured map we talked about. A patchwork of rules where a player could be a skilled analyst in New Jersey but an illegal gambler just across the river in a different state. The daily fantasy sports saga proved that even with a strong claim to being skill-based, The sheer amount of money involved and the inherent unpredictability of sports made the line impossibly difficult for lawmakers to draw. And just as the dust was beginning to settle on fantasy sports, a new controversy was brewing in an even bigger industry: video games. The issue wasn't about winning money directly, but about spending it. The culprit? The loot box. For anyone unfamiliar, a loot box is a virtual item you can purchase with real money within a video game, which contains a randomized assortment of other virtual items, like new character outfits, more powerful weapons, or other in-game content. The problem is, you don't know what you're getting until you pay and open it. You might get a super rare, coveted item, or you might get a common, worthless one. If that sounds familiar, it's because it uses the exact same psychological mechanic as a slot machine: variable rate reinforcement. It's the thrill of the unknown, the dopamine rush of a potential big win, that keeps people paying. This sparked a global debate. Are loot boxes a form of gambling? Game publishers argued vehemently that they were not. They claimed that since you always receive something of value, it's not a wager. And since the items are virtual and often can't be officially cashed out for real money, it doesn't meet the legal definition of gambling, which requires a prize with real-world value. They compared it to buying a pack of Pokemon cards or baseball cards. You don't know exactly what you'll get, but you know you're getting a pack of cards. But critics fired back, pointing out the glaring differences. Unlike a pack of physical cards, loot boxes are integrated into a highly immersive, 24/7 digital environment. The items within them can provide significant competitive advantages, creating a pay-to-win pressure. And a thriving unsanctioned third-party market quickly emerged where these valueless virtual items were being bought and sold for thousands of real-world dollars. Legislators and regulators around the world started to take notice. Belgium and the Netherlands famously declared that certain types of loot boxes were in violation of their gambling laws, forcing game publishers to either remove them or alter how they worked. In the United States, the response was once again a fractured patchwork. States like Washington and Hawaii introduced legislation to regulate loot boxes, with some politicians calling them predatory and specifically designed to exploit the psychology of addiction, especially in children. The Entertainment Software Rating Board, the industry's self-regulatory body, responded by adding an in-game purchases label to games, but critics said this was a toothless measure that didn't address the core issue of whether these mechanics constituted a form of gambling. The loot box debate pushed the skill versus chance argument into a new dimension. It wasn't about a player's skill anymore. It was about the very design of a product. Was it possible for a company to build a gambling machine directly into a video game, bypass all gambling regulations, and sell it to millions, including minors, simply by calling the prize a virtual item? This collision of technology and regulation set the stage for the next great battleground: esports. Competitive video gaming has become a global phenomenon, with professional players, multi-million-dollar tournaments, and a massive viewership. And where there is competition, there is betting. On the surface, betting on the outcome of an esports match seems straightforward. You are wagering on which team of highly skilled professionals will win, much like betting on the Super Bowl or the World Series. This seems to fall squarely into the category of sports betting, which, following a 2018 Supreme Court decision, is now being legalized and regulated by an increasing number of states. The skill of the players is the dominant factor, but esports introduces layers of complexity that traditional sports do not have. Think about it. Within a single esports match, there are countless micro-events governed by a combination of player skill and the game's code. For example, in many games, a powerful item or weapon might spawn in a random location on the map. A player's skill gets them to the location, but the random number generator, the RNG, in the game's code decided where and when it would appear. So what happens when you can bet on these micro-events? What if you could place a wager on which team will secure that randomly spawned item? Or what if you could bet on the contents of a virtual drop a player gets after defeating an enemy, an outcome that is also determined by probability and algorithms? Suddenly, you're not just betting on skill anymore. You're betting on the outcome of a digital dice roll that is embedded within the game of skill. This is where the legal framework begins to fray. Is this sports betting? Or is it an unregulated digital casino operating under the guise of an esport? The law has no easy answer. The technology is moving so fast that it's creating new forms of wagering that legislators in the 20th century could never have conceived of. From fantasy sports to loot boxes to the complex world of esports betting, the digital age has relentlessly attacked the traditional definitions of skill and chance. The core principles of the law, written for card tables and horse tracks, are being stretched to their absolute limit. So how do courts even begin to unravel this digital knot? They don't just flip a coin. They rely on a set of old, powerful, and often conflicting legal tools. Specific tests developed over decades to peer into the heart of a game and determine what truly drives it. These frameworks, known as the dominant factor test, the material element test, and the any chance test, are the final arbiters. And understanding how they work is the key to understanding the entire system. Let's start with the most common and, in many ways, the most intuitive of these frameworks, the dominant factor test. Sometimes called the predominance test, its central question is simple. What is the primary, the overriding, the dominant factor that determines the winner? Is it the player's skill? Or is it the luck of the draw? The test acknowledges that most games have elements of both. Life has elements of both, but it forces a decision. Which one truly sits in the driver's seat? Think about poker. Specifically, Texas Hold'em. Is there chance involved? Absolutely. You have no control over the cards you're dealt, or the cards that appear on the flop, turn, and river. That is pure, unadulterated chance. A beginner could get a royal flush on their very first hand and beat a seasoned pro. However, the dominant factor test looks beyond a single hand. It looks at the game over time. Over hundreds or thousands of hands, will the beginner keep winning? Unlikely. The professional's skill in calculating odds, in reading opponents, in bluffing, in managing their chip stack. These skills will dominate the short-term luck of the cards. The pro knows when to fold a bad hand, minimizing losses. The beginner might go all in on a weak pair, hoping for a lucky break. Skill in the long run is the deciding factor. That's why states like California and New York generally lean on this test. They see that while chance is a passenger, skill is the one steering the car. Now, contrast that with a game like roulette. You can have a strategy. You can bet on your lucky number, or spread your bets across the board. You can study the wheel for hours, but at the end of the day, your skill has absolutely zero impact on where that little white ball lands. The outcome is determined entirely by physics and probability. Chance isn't just in the driver's seat. It owns the car, the road, and the entire city. Under the dominant factor test, roulette is unequivocally a game of chance. This test is the battleground for many modern app-based games and fantasy sports. A company will argue that their game requires immense skill, pattern recognition, quick reflexes, strategic planning. The state might argue back that a random power-up or a lucky critical hit is the real reason people win, making chance the dominant factor. It all comes down to a granular analysis of gameplay, in which element a court believes truly predominates. But not every state is satisfied with just identifying the dominant force. Some jurisdictions use a much stricter standard, known as the material element test. This test doesn't ask what's dominant. It asks a more piercing question. Does chance play a material role in the outcome? Material is a legal term that essentially means significant, important, or having a real influence. Under this test, skill can be the dominant factor, but if chance is still a significant co-pilot, the game can be classified as gambling. This is where things get tricky. Let's go back to our poker example. Under the dominant factor test, it's often seen as a game of skill. But under the material element test, a prosecutor could argue that the random deal of the cards is, without question, a material element. You can be the most skilled player in the world, but if you're card dead for an hour, meaning you're dealt nothing but terrible hands, you cannot win. That element of chance is not trivial. It's a fundamental material part of the game. Your skill is in navigating that chance, but you can't eliminate it. Think of it like this: imagine a 100-yard dash. The dominant factor is clearly the runner's speed and endurance. But what if there was a rule that one random runner, chosen by a coin flip before the race, had to start 10 yards behind everyone else? Chance has now been introduced. Is it the dominant factor? Probably not. The fastest runner still has a great shot at winning. But is it a material element? Absolutely. It has a significant, tangible impact on the outcome. States like Florida have historically used this stricter interpretation, which is why daily fantasy sports companies have faced such intense legal battles there. They argue it's about the skill of drafting a team, but the state can counter that a single, unpredictable player injury, an element of pure chance, can completely derail a carefully crafted lineup, making that chance a material element of the contest. The material element test closes the door on many games that the dominant factor test might let through. It creates a higher bar, reflecting a more cautious legal stance that if luck plays any meaningful part, the game should be regulated as gambling. But we can go even further. There is a third, and by far the most severe legal framework, the any chance test. This test is as blunt as its name suggests. It asks one and only one question: is there any element of chance in this game whatsoever? If the answer is yes, even if that element is microscopic, the game is a game of chance. End of story. This is the nuclear option of gambling law. Skill becomes almost completely irrelevant. It doesn't matter if skill accounts for 99.9% of the outcome. That remaining 0.1% of chance is enough to classify the entire endeavor as gambling. Imagine a chess tournament where, in the event of a perfect stalemate, the winner is decided by a coin flip. Under the dominant factor test, chess is obviously a game of skill. Under the material element test, an argument could be made, but it's likely still a game of skill since stalemates are rare. But under the any chance test, the moment that coin is introduced as a potential tiebreaker, the entire tournament becomes a game of chance. This test is far less common today precisely because it is so incredibly broad. If applied strictly, it could theoretically classify almost any competition. The random seeding of teams in a tournament bracket? That's an element of chance. The weather conditions on the day of a golf tournament? That's an element of chance. A baseball hitting a pebble in the infield and taking a weird hop? Chance. The any chance test is a relic of a time when the legal system sought to draw the brightest possible line, eradicating any ambiguity. While few states rely on it exclusively now, its ghost still haunts legal discussions, representing the most extreme end of the regulatory spectrum. So let's take a single hypothetical mobile game and run it through all three tests. The game involves solving a complex puzzle. The faster you solve it, the higher your score. This is clearly skill. However, at the start of each round, you are given one of three random single-use power-ups. One that adds 30 seconds to your timer, one that reveals a hint, and one that does nothing. How would our legal system see this game? In a state using the dominant factor test, a court would likely find it to be a game of skill. A player's puzzle-solving ability, their strategy, their speed. These factors will almost certainly dominate the outcome. A great player who gets the useless power-up will still beat a terrible player who gets the extra time. Now let's move that game to a state using the material element test. The analysis gets much harder. The state could argue that getting 30 extra seconds is a massive advantage that has a material impact on the final score. It could be the difference between winning and losing a head-to-head match. The game developer would argue that skill is still more important. The outcome here is uncertain. It's a coin flip, ironically. Finally, let's take our game to the harshest jurisdiction, one that uses the any chance test. The result is immediate and clear. The moment the power-up is assigned randomly, the game contains an element of chance. Therefore, it is a game of chance. No further analysis of skill is needed. The case is closed. One game, three different states, three potentially different legal realities. This is the complex web that developers, players, and regulators must navigate. It shows that the line between skill and chance isn't a fixed, universal constant. It is a line drawn in the sand by the specific legal test a state chooses to use. And that line is constantly being redrawn as new forms of entertainment challenge the very definitions of skill, chance, and what it means to play a game. So what happens when a game is almost pure skill, but the outcome is still uncertain? Welcome to the billion-dollar battleground of esports. At the highest levels of competitive gaming like League of Legends or Counter-Strike, there is no roll of the dice. There is no random number generator deciding a match. Victory is forged through thousands of hours of practice, lightning-fast reflexes, and profound strategic depth. It is undeniably a game of skill for the players. But what about for the millions of people betting on the outcome? Is their wager a game of skill or a game of chance? The bettor isn't controlling the character. They are analyzing data. They're studying player statistics, team synergies, patch notes, and historical performance. Their skill is predictive analysis, identical to the skill a sports bettor applies when studying a football team's roster and injury report. This is where the legal framework gets twisted into a knot. The game itself is skill, but the act of betting on it from the outside looks an awful lot like traditional sports wagering, an activity that was, until very recently, illegal in most of the United States. The 2018 Supreme Court decision to strike down the federal ban on sports betting opened the floodgates, but each state was left to decide its own rules. And now, they must decide if a bet on a virtual athlete in a digital stadium should be treated the same as a bet on a physical athlete in a real one. The answer, just like with fantasy sports before it, is a chaotic and evolving patchwork of state-by-state legislation, with regulators trying to understand a world that didn't exist when their laws were written. And this brings us to the bleeding edge of the debate, the new frontier where the line between skill and chance is not just blurry, but is being actively erased and redrawn by a new kind of technology, the blockchain. Enter the world of Web3 and play-to-earn gaming. Imagine a game where the sword you earn by defeating a dragon isn't just a collection of pixels on a company's server. Instead, it's an NFT, a unique, verifiable digital asset that you truly own. You can use it, you can show it off, and you can sell it on an open marketplace for real cryptocurrency, which can then be converted to dollars. The prize element is no longer an abstract in-game item. It's a potentially valuable financial asset. Now, consider how you acquire these assets. In many of these games, you might pay real money to buy a pack of characters or a chest of items. But what you get inside that pack is randomized. It's a roll of the dice. You might get a common low-value character, or you might get a legendary ultra-rare one worth thousands of dollars. Suddenly, the three core elements of gambling are staring us in the face. You have consideration, the money you paid for the pack. You have chance, the randomized outcome of what's inside. And you have a prize, an asset with tangible, real-world monetary value. Game developers argue that this is a game of skill. They say your success and earnings are ultimately determined by how well you play the game with the assets you have. But regulators are beginning to view it with intense scrutiny. Is buying a randomized character pack a form of gambling? Is trading these assets on a marketplace a form of unregistered securities trading? The Securities and Exchange Commission, state gaming commissions, and Treasury departments are all circling this new industry, trying to figure out which set of laws even applies. It's a legal Wild West, where the definitions of game, asset, and wager are all up for grabs. This entire modern dilemma was foreshadowed by a controversy that has been raging for years in traditional video games: the loot box. Think of games like FIFA, where you can buy player packs, or Overwatch with its cosmetic loot boxes. You pay real money for a digital container, and the contents are a surprise. For years, the gaming industry defended this practice by arguing that the prizes, the virtual items, had no real-world value because you couldn't officially cash them out. It was, they claimed, no different from buying a pack of physical trading cards. You might get a rare card, but you can't walk back into the store and demand cash for it. But that argument began to crumble under the weight of reality. A massive unsanctioned gray market emerged. Third-party websites allowed players to buy, sell, and even gamble with these virtual items, effectively converting them into real-world currency. Suddenly, that rare digital skin for a weapon wasn't just a cool cosmetic. It was an asset with a price tag. This is what prompted countries like Belgium and the Netherlands to declare that certain types of loot boxes constituted illegal gambling, forcing publishers to change their games in those regions. In the United States, the debate continues to simmer, with proposed legislation frequently appearing but rarely passing, a testament to the slow speed of law in the face of rapid technological change. So, after this entire journey, from old carnival games to the poker table, from fantasy sports leagues to the digital metaverse, what have we learned? We've learned that the line between skill and chance is not a fixed, universal truth. It is a social and legal construct, an agreement we make as a society about what kinds of risk we are comfortable with. It's a reflection of our deeply human desires. On one hand, we crave mastery. We want to believe that our effort, our intelligence, and our skill can shape our destiny. Games of skill honor this desire. They provide a clear path from practice to perfection. On the other hand, we are fascinated by fortune. We are captivated by the idea that a single moment, a lucky break, a random turn of a card can change everything. Games of chance speak to this part of our nature, the part that hopes for a miracle against all odds. The law's struggle to separate these two is a struggle to balance our own internal conflicts. It aims to foster the virtues of skill, determination, strategy, and hard work, while attempting to shield us from the potential dangers of pure chance, addiction, exploitation, and financial ruin. The legal tests we've explored, the dominant factor test, the material element test, the gambling instinct test, are the tools society uses to draw this line. But technology is a relentless force, constantly handing us new games, new platforms, and new ideas that defy these old categories. The law is perpetually playing catch-up, trying to apply 20th century principles to 21st century realities. The poker player of the 1980s and the esports bettor of today are both trying to do the same thing. Use their knowledge to predict an uncertain outcome. But the legal world treats them in vastly different ways, based on a line in the sand that shifts with every new court case, every new piece of legislation, and every new innovation. The distinction between a game of skill and a game of chance is more than just a legal technicality. It is the story of our evolving relationship with risk, technology, and the very definition of what it means to play. And as we continue to build new digital worlds and invent new ways to compete and connect, the one thing we can be sure of is that the game is far from over. The line will be challenged, it will be debated, and it will be redrawn over and over again.